Good afternoon, and welcome everyone to the New Civil Liberties Alliance and to today's Lunch and Law program called Peekaboo Prosecutions. I'm Russ Ryan. I'm a senior litigation counsel here at NCLA. And joining us today are two brilliant legal minds, both of whom have familiarity with this regulator we're going to be talking about today. It's called the Public Company Accounting Oversight Board. It goes by the acronym PCAOB, and that acronym allows detractors to use the more derogatory term peekaboo. And it's actually pretty appropriate given the somewhat infamous secrecy and lack of transparency and accountability of this regulator, which we'll get into as we talk about it today. One thing I want to start with is, if I told you that this regulator has been around for 20 years and has so far investigated and prosecuted about 400 cases, anyone want to venture a guess how many of those cases have ever been either decided or even reviewed on appeal by an Article III federal court? Anybody want to guess, Clegg?
40% maybe?
Anybody?
3%.
That's a little closer. It's about 0.5%. There's only 2 cases in 20 years out of all those, say, 400 that have ever seen the courthouse doors. The rest of them have all been decided internally by the PCAOB, with a handful that got reviewed by the SEC on appeal. So we'll get into some of that type of problem with the regulator as we talk today. But let me introduce our panelists. First, we have Andy Vollmer. He's a senior affiliated scholar at the Mercatus Center at George Mason University. He's a former deputy general counsel at the SEC and spent a good chunk of his career at the WilmerHale law firm as a partner there. By the way,
or as some of us know it, Wilmer, Cutler, and Pickering.
Yeah, that's good.
Yourself.
We also have Mike Carvin. He's a partner at the Jones Day firm here in Washington, and one of the country's foremost appellate lawyers. Among the many highlights of his career is that he represented the successful petitioners in a case we'll probably mention several times today, called Free Enterprise Fund against the PCAOB, which the Supreme Court decided in 2010. And it's become a really important precedent in the area of separation of powers. And both gentlemen's bios are available through a link, I think, that we posted. They've got extensive credentials that if I spend time going through them all, that would take up the entire program. So I won't do that. But before we get too far into the weeds, let me just talk a little bit about this PCAOB. It was created in 2002 in the Sarbanes-Oxley Act, so it's been around for about 20 years. And it's a little odd because Congress created it explicitly as a non-governmental private nonprofit corporation under the District of Columbia law. It's based here in DC. It's got about 1,000 staff across the country. Its budget is about $300 to $350 million a year. So, not a huge regulator, but also not insubstantial. Basically, it was formed to regulate the auditing profession, and in particular, the accountants and accounting firms that audit publicly traded companies and broker-dealers who have to file financial statements with the SEC. It's subject to SEC oversight. SEC appoints the 5 leaders of the board without any involvement by the president or Congress, or at least no formal involvement. And so it's sort of an odd regulator, but something that Congress does from time to time and seems to be increasingly doing. But to start, Mike, why don't we just give us a brief summary of the Free Enterprise Fund case and what happened there, since you were personally involved in that?
Yeah, I mean, as you noted, PCAOB was one of these egregious examples of where they've pushed beyond the so-called traditional independent agencies to create creatures that are completely divorced from any kind of oversight or accountability, either to the president or even really to Congress, which I can get into in more detail. In all candor, our strategic goal, I'm a alum of the Office of Legal Counsel, and there's a case out there called Humphrey's Executor, which essentially blessed this headless fourth branch that the SEC, FTC, those cases where you can actually separate the executive power from the only executive named in the Constitution with the avowed purpose of freeing these agencies up from politics, which is another way of saying freeing them up from accountability to voters and popular sovereignty. So as a lot of OLC alums, I've always hated that case, thought it was very destructive. And the goal here was to say, well, there's got to be some limits on this independent agency theory. And what you had was that the PCAOB officers could only be removed for cause by the SEC commissioners. So you had a double for-cause removal. President could only remove the SEC commissioners in extremely narrowed circumstances, and the commission could only remove the PCAOB officers in extremely limited circumstances. And this created a complete wall of separation between the president and those carrying out his executive functions. We won the case on that theory. Frankly, our goal was, and that worked quite well, was Chief Justice Roberts wrote the opinion and wrote some very good language in there about how the president is vested with all the executive power. Separating enforcement from the president creates very serious constitutional difficulties. That language in there served, I think, to help some very recent, more serious challenges to so-called independent agencies. And in a couple of cases, in the last 2 years, the Supreme Court's distinguished Humphrey's Executor and said they only upheld the FTC back then because the FTC at that point was not exercising any executive functions. It couldn't enforce the law or bring enforcement actions. And I think in the wake of that, there's a number of lawsuits that are being contemplated or pending to go after the actual independent agencies because they obviously all exercise core executive functions, and they will be able to be challenged. So to get back to the PCAOB, a similar argument could be made that this removal at will by the SEC doesn't somehow bless the PCAOB. There needs to be some ability for the president to remove these people directly. And more importantly, the PCAOB is sort of a poster child of all the ways in which Congress has sought to immunize the enforcement of the law from the chief executive, or really even from any politically elected officers. Their appropriations are not done by Congress. They collect their own money. They're called, as was indicated, a private corporation. That means they're not subject to any of the statutory requirements like the APA, FOIA. They have, as I say, their own budget-making authority, which means they can pay. This is back in 2010. I think the head of the PCAOB was making about $600,000 or more when the president's making $400,000. So there's no accountability, a complete draw on the Treasury, a complete exercise of unfettered prosecutorial discretion without any oversight. So I would think, given the current environment, given where the court has recently held that single-member commissions or single-member agencies can't have for-cause removal restrictions imposed on them, that there might be a lot of valuable separation of powers challenges to come at the PCAOB itself. And as I say, that was sort of our goal back then, was to start this rock going down the hill. With the change in the court, I'm becoming increasingly more optimistic. We can talk about some of the other attributes of the PCAOB, but that would be the major thrust of any challenge to them at this point.
Now, there was also an appointments clause issue in that case that went the other way, I guess. But
well, it did. I mean, I don't know how much you want to. Supreme Court's never told us, this is really getting arcane, but if you're a principal officer, you need to be appointed by the president. If you're not a principal officer, you can be appointed by the head of the department. In other words, the SEC could appoint you. And I made a strong argument that how can this freestanding agency be anything other than principal officers? And then the Supreme Court's never really defined the difference between a principal and inferior officer. But in our case, they said, well, one of the main attributes is being able to be removable at will by somebody who supervises you. And it's true that the statute doesn't allow the SEC to remove the PCAOB by will, but we just held in the preceding page that that's constitutionally required. So now we're going to transpose that constitutional decision and say, since they're removable at will by the SEC, they're inferior officers. Yeah.
Andy, anything you want to add? I know you've got at least one.
I'm so glad you
issue
asked.
with that case, but why don't we get your perspective on it?
The main point to emphasize is what Mike just said. The free enterprise decision established a really important principle. It started to move away from Humphrey's executor, and that, which was like dominating thinking in Congress and really many places in the legal profession about how Congress could set up an enforcement agency. So for purpose of the development of the law, free enterprise is hugely important and very valuable. Russ is joking a little bit by turning to me because I have a hobby horse about it. Free enterprise was built on a false assumption. The parties agreed and the Supreme Court accepted for purposes of the free enterprise case that SEC commissioners had protection, like for-cause protection, from removal. And that's what led to the principle that Mike's explained to you about 2 tiers of protection. The SEC commissioners protected from removal, needing a reason, and then same for the PCAOB board members. The problem is it's not true about SEC commissioners. Nothing in the federal securities statutes imposes a for-cause removal protection for the SEC commissioners. And if it's not in the statute, it doesn't exist. The Supreme Court has held strongly in Celia law, I think that's the CFPB case, right?
Yeah.
That the president has inherent power as the executive to remove officers in the federal government. So there is, in my mind, no question that the president may remove an SEC commissioner for no reason, for any reason, except probably an illegal or unconstitutional reason. And so therefore, free enterprise has got a significant weakness in it. And I don't know what the court or anybody would want to do with that, but this could arise pretty soon because of the Fifth Circuit's Jarchese decision, which I'm sure most of you are aware of, where there were 3 separate constitutional holdings from the Fifth Circuit about flaws in SEC adjudications. And I think we're going to come and talk about that. But one of the flaws is that the ALJs at the SEC had 2 levels of for-cause removal protection, and therefore that was unconstitutional within the SEC structure. So it's one of the things I care about. I think that this is, it's unfortunate that the free enterprise case is built on this flaw. I don't think the Supreme Court ought to perpetuate it, and I would really like to file an amicus brief if the Supreme Court grants cert in Jarchese, which I think they're likely to do. So,
there's no need for that at this point.
Wait a minute. I'm not done. I want to file an amicus brief. On this point, I'm looking for a lawyer to represent me pro bono. So if you're with me on this argument, contact me.
If memory serves, didn't Justice Breyer make this point? I think it was in that case, right?
Yes, it's in his dissent.
Yeah, okay.
Just to get back to, again, my Melville-like, Ahab-like obsession with going after the SEC. It's also true of the FCC. There's few that have these explicit removals restrictions in the statutes, only because the FTC was, 1905, but the ones from the 1930s don't have it. And you now have Breyer's dissent, which has 4 justices agreeing there's no statutory restriction on removals. And then I think you've got, the majority saying that any statutory restrictions on removal are unconstitutional. So now you can go after the FCC and the SEC on 2 grounds. What should happen, and what I've advocated for every Republican president, nobody's ever taken me up on it, is the first day in office, you should just fire the chairman of the SEC, fire the chairman of the FCC, and get this to court, where I think you'll absolutely win, either on statutory or
They
constitutional
usually
grounds.
resign, though, don't they, Andy?
No, they hang. Well, it depends how adverse they are. It's not.
Oh, the chair. I'm just thinking about the chair, but the commissioners.
chair
The
can get
commissioners
removed,
tend to
but-
stay around.
Right.
Yeah, you're right. So, Andy, I don't want to dwell on this topic, but I just have to push back a little. I have seen some commentators argue that despite the statutory silence on removal, the fact that the commissioners have statutory 5-year terms, that tends to imply that Congress intended for them to be able to stay in their position during that 5-year tenure. I take it you don't buy that, but
The fixed period for the tenure of various commissioners does not protect against the president's inherent power to fire these people. And the statute specifying a term of years did not restrict the president's removal power in the Myers case, which was 29, 28, something like that. Free enterprise didn't bother them in free enterprise, and didn't bother the Supreme Court in Celia law. So
I really don't want to disagree with you, because there's a bad case out there, just to go down this rabbit hole a little bit further, called Wiener, where they did have 5-year terms, and they said if the goal is to, these involve judges, if the goal is to make them independent of the president, we will read in you can't fire them. Normally, a term doesn't necessarily mean the minimum term, it could be the maximum term, and they said in that case they would be a minimum term. So I think the argument on the other side was you had to read this good cause removal into the SEC statute, because otherwise it would mean the president could remove them if they committed murder. So, again, I don't care if we get there through statutory means. Anybody who agrees with me on the Constitution is not going to worry about this statutory question. It's a way of picking up some additional votes through the route that Justice Breyer articulated in dissent.
all right. So let's get back to the PCAOB itself. Andy, I know you've done some research in this area. When the board was formed in Sarbanes-Oxley, it was loosely modeled upon the so-called self-regulatory organizations that are overseen by the SEC for the securities industry, such as FINRA. Is that a fair comparison? Are they similar? Are they different? Or because I've seen some case law that suggests that they're all the same, basically.
They're similar in many ways, but there's a critical difference that seems to matter under the current state of the case law. Let me begin by saying the point for everybody to think about is the one that Mike raised. And that's the concern that I think the three of us have with the way Congress sets up entities under varying types of structures and then gives them significant governmental powers. But you lack some of the standard methods of holding the organization accountable or responsible if they were just federal agencies. So the two lines of authority are, there are cases determining when some entity Congress set up should be treated as an agency or establishment of the federal government. That's what happened to the PCAOB, and I'll come back to that. The second line of cases is about private organizations recognized to be private, but that are deemed to be state actors for various purposes. So, and those two lines of authority don't seem to come together, at least from my looking at it so far. So there are a great many similarities between the PCAOB and SROs. So just let me mention a couple of the critical ones. The SEC exercise, and let's say FINRA is a very good model of an SRO, self-regulatory organization. The SEC exercises close oversight. The PCAOB and SROs, FINRA, have to use rules extensively, and there's a very elaborate rulemaking process that goes through the SEC. The SEC has oversight authority over SROs and the PCAOB. The SEC may amend the rules of these two different kinds of organizations, and the SEC reviews disciplinary decisions by the PCAOB and SROs. Both the PCAOB and SROs, FINRA, have extensive legislative power, that is, they write rules, executive power, they investigate potential violations of law, and then judicial power, that is, they reach adjudicated decisions on violations. And those final disciplinary cases go up through, can be reviewed by the SEC. But the PCAOB and SROs differ in a key way. One way that's important, and I think we'll talk about, is they differ on funding. FINRA operates independently, imposes fees on the members, sets its own budget. Not true at the PCAOB. The SEC has pretty careful review of the PCAOB budget. But here's the critical way they differ. The Congress or the government created and provided for the appointment of the PCAOB board members. And under the line of authority about what makes a thing an agency, that's the key factor. So it's a case called LeBron, which came up in Free Enterprise. It's about Amtrak, and the Supreme Court puts a lot of weight on the Congress creating the entity, but then having some sort of governmental appointment of the governing body. And that's true at the PCAOB. The SEC appoints, and we now know, removes PCAOB members. That's not true at the SROs, not at FINRA. Law provides for the existence of SROs, and in fact, many of you might know, requires broker-dealers to be members of an SRO. Oh, by the way, the only SRO you can be a member of is FINRA. So you must be a member of FINRA if you're going to be a broker-dealer. But Congress didn't set up FINRA and didn't provide for the appointment. There's a pretty elaborate governing structure at FINRA, but it's all was done by the members of FINRA when they organized FINRA. So that's the big difference. And as I say, the case law treats those things that are agencies, they are, like PCAOB, treated as part of the government for constitutional purposes, is what the court said in Free Enterprise. So that's why the appointment clause applied. That's why the removal issue and the president's power to remove came up, because the PCAOB is treated as an agency for constitutional purposes. But big gap on a bunch of statutory protections. I'm sure we'll come back to that. But none of that is true at the SROs. The case law is, are they a state actor? And the courts are entirely schizophrenic about FINRA. That is, you don't have constitutional rights during a FINRA enforcement investigation. Can't take the fifth without with having the same protections as you do during a governmental investigation. But the courts, on the other hand, say, oh, but FINRA is immune from liability, which generally applies to agencies. So my view is I think we have to think deeper about these two lines of authority because they ultimately care about government control. And there is enormous government control of both the PCAOB and FINRA. And so I just think we're ripe for a rethinking of this whole area of law and Congress's ability to transfer all these powers to different kinds of organizations.
Well, one thing I'm focusing on is, the cases you mentioned, Amtrak, LeBron, I think they generally deal with the legislative powers exercised by these organizations, the rulemaking authority, and whether that's okay, as long as it's subject to government oversight. And here, I think the PCAOB's rulemaking is, in fact, subject to SEC close oversight. No rule can become binding unless and until it's approved by the SEC. But I distinguish that from the PCAOB's executive power and what you referred to as judicial power. I would probably call it pseudo-judicial. I think it's technically executive power as well, but that's the adjudication function. But when you're talking about investigations, discipline, sanctioning, adjudications, all that activity at the PCAOB goes on with no supervision by the SEC. The only time the SEC gets involved is when all the damage is done at the end of the process. If the respondent is still standing and still has money to appeal, can appeal it to the SEC. But that's happened less than 10 times in the 20-year history of the PCAOB. So not only are these people not getting to court, very, very few of them, less than 1%, are even getting to the SEC. So I do draw that distinction, and I think that's something that can be emphasized in future litigation and really focused on, that there is no real-time supervision when the PCAOB flexes its executive and pseudo-judicial muscle. Do you agree with that, or am I off base on this?
I do agree with it, but I wonder if Mike, I've talked a lot, so I wonder if Mike wants to
can you
come in?
Do you distinguish it? Do you cut it up that finely when you're determining whether an organization has sufficient government supervision to be constitutional?
Look, I would throw out rulemaking and enforcement, but I draw your distinction. I understand your distinction, which is the whole theory about these government agencies vested with enormous state powers to call them private, and try and get them outside, because what they're trying to do is vest them with a lot of power and not have any accountability to the Constitution that state actors have to go through, or all the statutory protections people have. So you can go into this, and correct me if I'm wrong, I'm sure Andy knows more about this than I do, but I mean, it really is a star chamber proceeding, right? There's no discovery. If I understand it correctly, they don't even tell you their prior precedent. They know it, but they don't publish it, so you don't know what ground rules there are. Sort of the most basic check against arbitrary and capricious.
They do publish the ones where they win.
Yes, exactly. Right.
But if they lose, unless it gets to a court, the SEC or a court, but the ones that they lost, if any, I don't know.
It goes into a black hole.
It's
and so
completely behind the vault.
And then their ALJs. This is one line of attack to get in a slightly different ways. The hearing officers have tremendous power as well. And there's an appointments clause issue there, because again, correct me if I'm wrong, I don't think the SEC appoints these hearing officers, and they're the head of the department, so they've got to do it. I think they just approve what the peekaboo does, and that's not an appointment. That's what the Senate does for the president's appointments. That doesn't mean that they're the appointing entity. So again, I don't want to get too far down this.
Well, here's what they did. When Lucia came up, we'll talk about that case too. When Lucia came up and said that the SEC ALJs were not properly appointed, people at the PCAOB and the SEC, I think, realized, we've got a hearing officer who does essentially the same thing as an SEC ALJ. We better cover ourselves on this. But what they did was they agreed that henceforth the PCAOB would appoint its hearing officers subject to SEC approval. I don't want to go down this path because we'll get stuck in it.
No, so the only
I don't think it satisfies the appointments
big picture
clause.
is it's a very bad system where you can have these unaccountable adjudicators who are deliberately clothed in the protections of being a private entity without any kind of recourse. I was just trying to throw out a few examples for people who want to come at that. You have to come at it a little bit more indirectly, but there is ways to challenge this thing. And we haven't talked about Thunder Basin and your guys' case. And some of these things can be brought to court without going through the torturous process if you prevail in the Supreme Court.
Yeah.
So I strongly agree. Well, I agree with Mike's point about I wouldn't even treat rulemaking differently, really. I mean, there is close supervision, but that's the wrong rule. It is the rule from your famous horse racing case that you told me about.
In the Fifth Circuit, just a month or so
But
ago.
Russ's main point is so important because so the PCAOB is this oddball thing out there, and it can start an investigation of a public accounting firm and investigate it. Nobody knows. Nobody knows. The SEC doesn't know about it. They can bring a case, and that doesn't have to be sent to the SEC. They don't have to be notified unless there's a securities law violation involved. And if the private party, the regulated party, wins, the whole matter disappears. Now, the PCAOB does have an obligation to notify the SEC of a disciplinary measure. So if the staff wins, finds a violation, there's a sanction imposed, the SEC needs to be notified about it. But the point is there's this huge gap in the operations and important operations of the PCAOB that the SEC does not know about day to day. Now, keep in mind the SEC will have reviewed the rules that apply. That's something. But in terms of supervision of day-to-day activities, that does not occur.
All right. Well, let's continue the comparison with the SEC. Mike, you mentioned a few things. There's a parallel between the hearing officers at the PCAOB and the ALJs at the SEC. But let's talk about the Lucia case from a few years ago, where the Supreme Court held that the ALJs were not constitutional. Do you think that actually translates into how you would analyze the hearing officer at the PCAOB, or are there distinctions that we're glossing over here?
No, it needs to be, not that I'm certainly aware of, and if there's any difference, it's in the details. I would think you'd have a stronger argument for bringing these people under control for all the reasons Andy just said. I mean, there's really no review until the whole process is over, which is fairly amazing. And so no, I think there's a very good argument that they need to be appointed by the head of the department. They need to be appointed initially by the SEC under Lucia, and they're just not done. After the fact approval is not appointment. I can approve of a lot of appointments that I wouldn't have made initially. So there's.
No, go ahead. I was just going to say, have you given any thought to the removal problem? How hearing officers at the PCAOB can be removed, and whether your free enterprise fund precedent would make them vulnerable under that too?
Oh yeah, and again, I don't want to. We're really getting into Nerdsville here, but I've actually got a case.
Oh, please, let's do it.
No, I've got a case in the Fifth Circuit actually now challenging the removal provisions for SEC ALJs, or my case involves DEA ALJ. But it's the same problem. And again, this is the nerdy part. Nobody can remove these guys, not the president. You have to go through the Merit System Protection Board, which is also a so-called independent agency, which is only removable for cause. So you have the double for-cause removal that was the basis of the decision in Free Enterprise Fund, that entity insulated from presidential control, in this case the Merit System Protection Board, is making a decision about an underling who is also insulated from removal. And so I think there's a very straightforward argument, frankly, under the express holding of Free Enterprise Fund that the ALJs are vulnerable.
So Lucia said that ALJs at the SEC were inferior officers and needed to be appointed in compliance with the Appointments Clause. But do you think that the PCAOB hearing officers are inferior officers? Because one test, now the main test is significant authority. The power of a hearing officer at the PCAOB is pretty similar to
Yeah, I think so.
SEC ALJs. But here's one difference. The SEC ALJs report to a principal officer. And that's an element in free enterprise for the distinction between an inferior officer and an employee. But that's not true at the PCAOB because the hearing officers report to the PCAOB members and they are inferior officers. So
Yeah, I think that's a great point. Great point.
Well, so it's an analytical point, and it's one I think people are going to have to think about. But I actually think in the end it makes things worse because what you're doing is distancing people with a lot of power from the federal government and whatever the Constitution's controls, the president's removal powers, statutory controls on agencies. So you're increasing the distance of the hearing officers from all of that and what I hope everybody understands now, also from federal courts. So you've got a PCAOB hearing officer, it goes up to the PCAOB board, footnote, what qualifies them to be adjudicators, for heaven's sakes? PCAOB board reviews the hearing officer, and then there is an ability to go to the SEC for review. So now you've got 3 steps before you, someone who claims innocence, didn't commit any violation, before you can even go to a federal court. And remember, the review will be limited on facts and law. So maybe there's an analytical point here about PCAOB hearing officers,
Oh, no,
but it's just like
I think
a
it's
problem.
more than an analytical point, right? You have 2 layers between the president and SEC ALJ. You have, as you articulated, 3 layers between the hearing officer at the peekaboo. So by the basic logic of free enterprise fund, the farther you are from the president, and there's no test, I don't think, that can suggest these people are mere employees. They have to be officers because they clearly exercise significant governmental authority. So I think it's actually a stronger case than you have
On removal.
On removal,
Right.
Yeah.
But not on appointment.
No.
So we talked a little bit about, we mentioned at least Jarcassi, the Fifth Circuit case that's, I guess we're still waiting to see if the SEC is going to seek cert in that case. They were denied rehearing by the Fifth Circuit. But one of the holdings in that case was that SEC adjudications violate the respondent's right under the Seventh Amendment to a jury trial, at least in some cases. And they emphasized the fact that it was a fraud-based charge, which is not usually the case in PCAOB proceedings, but nevertheless,
But could be.
it could.
But generally not.
But nevertheless, I mean, it seems to me that if Jarcassi stands up, that presents yet another vulnerability towards PCAOB adjudications. So do you have any thoughts on that?
I think that there's less exposure for the PCAOB on that question. That's a separation of powers issue, and whether the agency-like thing is allowed to exercise judicial authority. You can call it executive if you want. I know some Supreme Court justices say that, and it's just, to me, total rubbish. Because the PCAOB is a specialized structure, and the violations don't resemble common law claims. I mean, except, as I said, if the PCAOB asserts a securities law violation and asserted like a 10b-5 claim, then it would be. But
these are basically audit negligence cases, aren't they? I mean,
Well, yes,
I mean,
they could.
yes,
So you want to
they're rule
analogize them
violations,
to a
but-
tort case? So
and they seek sometimes draconian penalties.
they do.
So
absolutely,
you
that's
combine
true.
those two things, and that sort of screams out to me that we ought to have a jury somewhere in sight in this case.
So I think about it slightly differently. Because I think that aspect of Jarchese is wrong based on current Supreme Court doctrine, which, and like, I'm very sympathetic to your main rebuttal, which you're already formulating in your head. But I think under the current way the Supreme Court approaches these things, the question is, can you have the adjudication, the determination of whether somebody's committed a violation of law, sent to an administrative agency of some form, like the PCAOB or the SEC? And their approach to that question is the public rights doctrine. And the public rights doctrine, although it's not consistent and we can argue about it,
That's an
basically
understatement.
holds that if this is a claim from the by the federal government against somebody under a new statutory scheme that Congress created, then Congress may send that question, that litigation question, to the, I'm going to say, agency, treating the PCAOB as an agency just for this moment. That's not how the Fifth Circuit analyzed it. The Fifth Circuit analyzed it, I think, in two ways that I question. One is they said, oh, this is just like common law fraud claim, because it was a 10b-5 claim. And they said, it just looks like fraud, and that's a common law claim. Juries tried common law fraud claims all the time. That's basically Seventh Amendment analysis. What was happening in 1791? Well, juries could hear fraud claims. And so the Fifth Circuit said, like, basically, QED, how can you do this at the SEC? You've got to have a jury. But the way the Supreme Court approaches it is they apply the public rights doctrine first, and then they say, if it falls within the public rights doctrine, that is, it's a public right, it's the federal government bringing a claim under a new statutory system, there's no Seventh Amendment question. Mm-hmm. So the Seventh Amendment follows along in little footsteps.
Which makes literally no sense, right? That Congress can write a law in a way that deprives you of your ability to get at a jury. I will stipulate that the public rights doctrine, the notion that there is such thing as a coherent, the way the Supreme Court approaches the public rights doctrine is a non sequitur. They're all over the place. They don't make any sense. The only way it made any sense at any point was, well, we're not really depriving you of anything because if you were suing the federal government, that's the way they came. So they said formalistically, well, they've waived their sovereign immunity, so they could have the guy at the local pizzeria decide this case. You've got no claim. Everything they give you is a privilege, which makes some sense in the sovereign immunity context. It makes no sense when you're living your life and the government comes after you to take away your money. There's no notion of any waiver of sovereign immunity. So it literally can't be that Congress can label some right public and then deny you of a jury, particularly when Title VIII, the Fair Housing Act, was held to be analogous to common law analogs. The only question is whether it's an equitable claim that you would have never gotten a jury on anyway. The final point on all this is Article 3 is also implicated, right? The basic premise is this whole notion of having judges who are subject to being fired and promoted by the prosecutors obviously raises some issues. And the way we dealt with that in the Constitution was to give Article 3 judges life tenure, so they would be free of these controls. Well, now you're in a situation where, and the public rights doctrine has been used sometimes to get around the fact that you need to go to a federal judge with life tenure. And I'll just point out, in this situation, it's completely exacerbated because of the reasons we just talked about. Under the removal provisions of the Constitution, these people need to be removable at will. In other words, they have basically no protections. If I just disagree with them or I think they're too nice to these poor accountants, I can fire them. That is literally the polar opposite of what you're trying to create when you're talking about Article 3 judges. I know this is all very complicated, but the common sense of the notion has to be that you can't waive jury requirements and Article 3 requirements because of the label you attach to the congressional statute at issue.
Yeah, I've never bought into this notion that Congress can create essentially a government prosecutor or a quasi-government prosecutor, and when they prosecute you, that's a public rights. Why isn't a criminal case a public rights under that
every
theory?
statute a public rights case. They were created by Congress. They're protecting the public. So anyway.
That is the quintessential private rights case, when the government's coming after you and trying
your
to
money.
brand you a wrongdoer, take your money and take your liberty.
Yeah.
I think, we could all agree that the public rights doctrine is
The only good news is
whack.
they're so confused, they've got to rethink it. No, I'm serious. They're just all over the place.
Let's go back to the funding issue. You mentioned it early on, Mike, and I think it's a big one, especially in light of there was a Fifth Circuit case a month or so, I think within the past few months.
Yeah,
is that your case?
Yeah, yeah.
Oh, okay.
And
So
that was the
CFPB, right?
right. And the CFPB has, and again, all part and parcel of the notion that we don't want any elected official accountable to the public to ever review these super empowered agencies. And the way they did it in the CFPB was, instead of giving them an annual appropriation or making them come to anybody in the budget process and say, we can justify our existence, they literally they draw on there's a cap, but they can draw basically whatever they want and do whatever they do. And the Fifth Circuit struck that down. I'm going to be a little careful because there's a cert petition pending. So we're trying to deny review. So I'll say this is a very inconsequential case.
Nice.
That doesn't really matter, but you could apply similar reasoning, I'll just leave it at that, to the way that the PCAOB is funded. We draw certain distinctions between the way the Federal Reserve is funded and CFPB. CFPB, again, is so far removed from the normal budgetary process that the Fifth Circuit said look, the power of the purse resides in Congress. It's one of the most important checks on executive or abuses. And they've, again, systematically eliminated that ability for the people to rise up and say the CFPB has gone nuts and do anything about it.
Yeah, I would argue the PCAOB is even worse because not only does it not get an appropriation from Congress nor need to seek one, it sets its own budget, and the only one who reviews it is the SEC.
And I'm going to interrupt you. No, you go through arguments, you wonder which points are going to resonate. When everybody found out the chairman of the PCAOB was making $200,000 more than the president, they were like, oh, now I understand what you're talking about, unaccountable. And anyway, sorry.
Well, no, I think that flows from setting your own budget, and the way they fund it is not with public money. I would argue it's effectively they levy taxes on public companies and broker dealers. Every year they say this is what you owe for our accounting support fee for next year. And
Andy, I'm interested just because this is an interesting point. Theoretically, I know not realistically, you could resign from FINRA, right? I mean, if they assess you this fee, it's got to be a tax, right? Because it's not like you can say, sorry, I'm going to give it to the boys club this year, right? It's not a fee. Am I right about that?
I think that's right. And I mean, you could, I suppose, just say, well, we're not going to audit public companies or broker dealers, and we're going to.
But I don't ever think that's a genuine choice. To say,
no.
Well, you don't have to be a broker dealer.
You don't have to be.
You don't have to join FINRA because you don't have to be a broker dealer. That cannot be the answer.
Or you don't have to be an American citizen, right? I mean, at some point, these things become a little too extreme.
Yeah. Andy, am I overstating that the way they fund themselves is they levy taxes, and that's supposed to be a power that only Congress has?
Well, I just would. I don't want this to be a big quibble because I basically agree, but it's a user fee. So a lot of times, think about your airport taxes and things like that. So they're not broad-based in the sense of generally applicable to many, many, many people. It's the sector that's affected. But it is a tax.
But I'm sorry, that's true of FINRA, but I don't know that that's true of the CFPB. Now, maybe you may be distinguishing PCAOB.
I was.
Okay,
I
sorry.
was. Yeah, CFPB
Is
gets its money. Well, you know this much
Yeah.
better than I. By the way, congratulations. That's a great result. But I want to ask you about the cert petition, which I looked at.
it's entirely.
But the
various.
Fed has, the CFPB gets its money from the money the Fed has.
And I didn't want us to get distracted. I just wanted to make sure the distinction.
Well, but
between
how
the
narrow
CFPB
is that base? I just
Oh, they
don't know.
can draw whatever they want. I mean, I think, I forget the cap, but it's some cap. But within that cap, they can fund whatever they want.
But the Fed's fees come from
No,
banks.
right. That's right.
Banks.
So and again, we keep doing this. It's a hip bone, thigh bone connection, right? The Fed gets it from the banks, and then the PCAOB has carte blanche to take whatever amount of money they want. But you have to call the Fed's monies federal funds, right? And they're not appropriated by Congress.
So I don't know a huge amount about this area, nothing like Russ and Mike. But I did take a look at the cert petition, and the thing that troubles me, and that I think will trouble some of the justices and law clerks, is that the history of the country is that Congress has approached regulatory questions with the greatest imagination, and have imposed fees, funding methods of funding through fee imposition, narrow and big, of all different varieties. So I think a great source is the LeBron opinion. You probably remember at the beginning of the LeBron
The whole
opinion,
Amtrak thing, yeah.
they just go through all kinds of different structures that Congress has made up. I don't know if they deal with funding.
You can read our brief in opposition to the cert petition, but I can distinguish all those cases because at the end of the day, no, they are user fees, and that's why I wanted to make the point, unlike the PCAOB, you can't characterize what's funding the CFPB as a user fee. There's no users, there's no members.
right.
They go after anybody for any reason, and they're drawing on. The example I would use is if they said, well, take whatever percentage of the Treasury Department's budget you want. You couldn't say, well, we've appropriated money vis-a-vis the Treasury Department to the CFPB. And the same thing is true when they say go after the Fed's budget and take whatever you want. In either instance, they're drawing on a pot of money, and admittedly from user fees as opposed to direct appropriations in this circumstance, which is federal funds that can't be misused and are subject to all the restrictions on federal funds. And so we're arguing that you can call it a non-delegation issue or whatever you want. Power of the purse is Congress's most fundamental power and check on executive agencies. It literally can't write a blank check to an agency and say, go get whatever amount of money you want to do whatever you want. And that, absent the cap, is exactly what they're telling the CFPB.
So the SG's position, I'm just going to allow you to rehearse. The SG's cert petition says, this is to respond to this CFPB funding thing, that it meets the appropriations clause of the Constitution because all that's required, according to the SG, is that a congressional enactment state that an entity may use a specified amount of funds from a specified source for specified purposes. And that stands, so
That's got to be
and
wrong.
her conclusion is, well, the CFPB's funding is set up in a statute. That qualifies as an appropriation, meets the appropriations clause. We're done here. And
Right.
Mike says,
Under that theory, you could say, here's this thing we're going to call the Justice Department. Go get whatever amount of money you want in perpetuity and go to the federal treasury. We passed a statute. There's an appropriation. It doesn't tell you how much money or what it's being used for. And it's not like Medicaid or Medicare where they have very specific formulas for who's entitled and how much you can do. It's literally a century, decades-long authorization, and you can call it in those circumstances, nobody would argue that Congress is making the decision about how much the Justice Department gets. The Justice Department is making its decision about how much money it wants. And those are two fundamentally different things. And that's why her analogy proves far too much.
And what's critical to me is, and the premise for this whole discussion today, is we need to look particularly hard and carefully at entities that have enforcement powers. And
Agreed.
I add to that adjudication and sanctioning powers. So it's not only the power to investigate, which is brutal, by the way, for any of you who are not enforcement lawyers. It is a terrifying thing to be involved in a government enforcement investigation.
Can I just echo that? Because I think that's really how we got here, and I'll shut up in a second. But it started out with things like Legal Services Corporation and the satellite, ComSat. So they would create these sort of quasi-private corporations, but those people were involved in giving away money, right? They weren't harassing American citizens for non-compliance in this brutal process. So I just want to echo Andy's point that somehow it morphed into something where it was okay, the Smithsonian or whatever, you want to give them a fair amount of discretion. But then they started applying the same rationale to people with core enforcement powers, and that raises a host of fairness issues and separation of powers.
I totally
And
agree
it's
with that.
all compounded when you give that same entity what I call the judicial, the power
Right.
to
adjudicate
impose
themselves.
sanctions.
Yeah.
It's just extraordinary, extraordinary. And if you think about the PCAOB members, who are all private, have the power to appoint the hearing officer and remove the hearing officer. And do you think you're going to get a fair shake from that hearing officer? I think there are huge impartial decision-making questions about the PCAOB, and I believe the same thing. I have the same worries about the SEC ALJs.
Yeah.
So this should really trouble you a lot.
So I think we're down to about 5 minutes. I thought I'd just let you each kind of give us some final takeaways. Anything you'd want to say that we haven't covered yet? Thoughts like that?
Well, the switch from the general to the specific, I think we've made the general points perhaps too often about how dangerous it is to invest an entity with huge governmental power and then vest them with the ability to restrict any kind of oversight by the democratic process. And that is greatly exacerbated by the point that Andy made, which is they're not just the prosecutors, they're prosecutors, judges, and juries, right? And if you look back at the debate during the New Deal, that was what they were focusing on as the real problem with these independent commissions, that they've got the ability to be both prosecutor and judges of their own work. These sort of piecemeal attempts to create some insulation between ALJs and the agency that they represent help a little bit, but I think the whole structure needs to be very seriously questioned, particularly in a situation like this, where there's no basic restrictions. And then my final point, which now we're getting into a whole new area of the laws, you can't go in a number of circuits right now and say this ALJ is blatantly unconstitutional. We don't want to go through an unconstitutional hearing. They have this invented Thunder Basin theory. Oh, well, we've got it's an unconstitutional hearing here, and the ALJ can, of course, rule on his own constitutionality. But what you do is spend the next 2 years and $5 million, and then you get limited appellate review after the end of the process. So go through the, after they've imposed the death penalty, let them execute the sentence, and then you can appeal. And so I'm quite confident that the NCLA, this was also, by the way, the argument they made in Free Enterprise Fund, that we couldn't bring that. I thought it was the dumbest argument I'd ever heard. I devoted 3 pages of it to my brief. We won 9-0. But then for some reasons, the lower courts started buying it, and now you guys are going to undo all that bad nonsense. And I know but the procedural point is you need to be able to get in and challenge the system before it imposes its burden on you, not wait to some appellate court review 3 years down the road.
Yeah, and hopefully that'll get decided. Plug for NCLA. We're before the Supreme Court in the Cochran case on that. But yeah, I agree with you 100% on that. And I think it is a huge issue.
So my last word is that we've, and I hope I've been clear, that we really need to rethink the flexibility Congress has to set up these different organizations. And again, my main concern is with, I'm going to call it an enforcement agency. So really important governmental powers that hurt private citizens. We can't, there's just no justification for according that much flexibility to Congress when there's that much power being applied to private parties. And we need to rethink it. And as for the PCAOB, I think it's easy. We've got to get rid of the PCAOB. There's the justifications for it were weak in 2002, whenever Sarbanes-Oxley got passed. People in Congress got all ginned up about we got to have an independent auditing regulator, and we've got the PCAOB, and it's been a disaster in many, many ways. This is I don't love the SEC. I think the SEC has many, many flaws, but the PCAOB's function fits squarely into the SEC. And I'm not saying there shouldn't be regulation of public company auditors. There probably should be some, but there's no reason for this bizarre organization called the PCAOB.
Would you fold it into the SEC?
Why? I apologize. I just think it was a completely Pavlovian reaction to the Enron scandal, right? And then they decided, there's some fundamental flaw in how we regulated auditors. And I kept asking myself, why do they need to create this? Why didn't they just give the SEC authority? So it never made sense from the outset. And it's these outliers like the CFPB and the PCAOB that are designed for the avowed purpose of departing from the norm that I think would be most vulnerable to these various constitutional attacks.
So let's turn to some questions. Who's got questions? Who's first? Okay, John.
There's a lot of statutes that require money that the agencies take in to go back to the public fisc. And then there's some where they get to keep the money. Like the FDA, you pay a huge fee when you want to get your drug looked at by the FDA. You pay a huge fee. The FDA keeps that and uses it to okay your drug or not. And something Mike Carvin said. Here's the question: where is the limiting principle? Because money comes into the government a lot of ways, and then Congress directs it. Could Congress, for instance, say the Justice Department is funded by civil fines and civil asset forfeiture, and they could fund themselves in perpetuity because Congress said that's where this money goes? And I'm just wondering, there's a lot of income streams that Congress runs besides taxes, it seems to me. And what can they do and not do with that and still allow the agency to be constitutional?
Well, maybe Mike might be better, but I could say one thing, that would be a huge due process problem. And the Supreme Court's already said that if the adjudicator has a financial interest in the outcome, this goes back to the mayor's courts cases, that's obviously problematic. So I'm not concerned that Congress would go that far. I mean, who knows, but.
Well, you've, I think, highlighted two serious, I think, abuses, whether I think they fall outside of the appropriations argument I'm making, but you undoubtedly know about these civil penalties and them just grabbing, real property, your money at an airport, and then making you come back and prove to them you're innocent before they'll return the money to you. And then under the rubric of user fees, look, I don't have any problem if they want to charge people $1 to get into the Smithsonian, God bless, or Yellowstone. But these user fees have become a euphemism for people we've decided we're going to target. We'll not only make them give in to our discovery demands, we'll make them pay for our Xeroxing of their discovery demands. And that's the other problem there. So I don't think the lines are that difficult to draw. And I don't think the CFPB case, if the Supreme Court decides for some reason to review it, will draw that line because the CFPB is sui generis.
By the way, the PCAOB tries to avoid that issue. Whatever penalties it collects, it puts into a fund, and they they dole out scholar accounting type education.
Oh, is that
It's in the
scholarships.
statute.
Yeah.
I didn't know that.
Keep tab, checks.
Because then, and the other, and this is probably a minor point, is, and again, Andy, I'm sure you know, the SEC, I think they're trying to get it back to the victims, but the record in that is quite spotty about actually getting it back into the hands of the people who have been defrauded.
Yeah, the fines go to the Treasury, but you're talking about disgorgement.
Yeah, disgorgement.
And there's a bunch of case law on that. But,
Mark?
Yeah, Mike, we might have to have you back on a different panel after the Supreme Court denies cert in your Fifth Circuit case, or maybe after the Second Circuit rules in our parallel case on the law offices of Crystal Maroney. Maybe we'll have a circuit split, or maybe we'll have two circuits that have decided that CFPB funding is a problem. But I thought you might be the perfect person to answer this question, because you were involved in Free Enterprise Fund, where you have the double layer of protection problem. And then, to me, one of the problems with CFPB funding, in addition to what you said, is there's a double layer problem there too. They're not. They're getting their funding, as you said, from the Fed, which also isn't getting its money from Congress. So even if you wanted to say that the way that the Fed is funded is fine, there's still that double layer problem, it seems to me, when it comes to the CFPB, which, as far as I know, is completely unique across the whole government. So if the Supreme Court strikes down the funding mechanism for CFPB, I don't know that really hurts any other agencies. Do you have thoughts on that sort of double
No, we've
protection?
been looking at this very carefully, obviously, and no, they are sui generis. And the intuitively powerful point that you just made was what the Fifth Circuit went off on, right? It's one thing to say the Fed can fund themselves through these various mechanisms, but then if you have another stranger the for-cause removal is you're 2 steps removed from the president. The appropriations analysis is you're now 2 steps removed from Congress. And whatever you want to say about the power of the purse, it's got to encompass funding a completely independent agency that's not overseen by the Fed. It's not like the SEC and PCAOB. They've given all kinds of autonomy, and the notion that you can just point to Fund A and say, well, go get your money from there, and that avoids the appropriations problem, that can't be right.
Mike, you argued that, and there was somebody who was the Solicitor General at the time who argued on the other side. Is there anything about about who that was that gives you that gives us some idea about how the Supreme Court now might be deciding these things?
No, it was Elena Kagan, and let me just say I haven't put her in my most likely vote category, regardless of her experience as Solicitor General. The joke I made with her at the time was, this is a unique case for the Solicitor General, because if you win, you win. But if I win, you win, because your boss now has a lot more power than he otherwise would have if I didn't have it. It's always strange for me that the Justice Department will go in and argue that the president has less power than the Constitution vested in him. You never see it in Republican administrations. Unfortunately, you see it a lot in Democratic administrations. But for some reason, I don't know when it got politicized or how it got politicized, but separation of powers, I'll call it the common sense view or the textual view of separation of powers, has now been associated with conservatives, but there's really no reason for that, right? I mean, there's a lot of at least thoughtful liberals out there who would be just as worried about governmental abuses and concentration of powers. In fact, you think they'd be maybe more concerned than Republicans, but it has become ideologically charged. So my operative assumption, frankly, is that the 3 Democratic appointees won't support, and the other 6 are where you're going to pick up your votes.
I actually have a question for Andy that I never got to. Would it satisfy you if Congress just folded the PCAOB into the SEC, which occasionally percolates up from some proposal in Congress? I think there's one pending right now that really hasn't moved, but that's one way to at least lessen some of these problems.
Can I interrupt?
Sure.
Just because would they still have the multi-member commission structure and make it an entity within the SEC under this proposed legislation?
I think it would just become like a division.
Yeah.
Or an office, like the Office of Public Company Accounting Oversight.
well, that's how I thought of it, rather than totally folding it in, not with the board members.
Yeah, the board members would be gone, I would think.
This would just become part of the bureaucracy of the SEC, in my view. And yes, I think, unless you tell me I'm missing something, I would be content with that. As I said, I'm not supportive of everything about the way the SEC operates, but in particular, I would remove, and this is a whole different panel, Mark, I would remove any adjudicatory powers from the SEC and the FTC and other enforcement agencies, but you don't need them. It causes all kinds of complications. It causes unfairness. And so I would not allow PCAOB adjudications to be folded in, and I would like to see the SEC lose its adjudication power.
Wasn't that part of Jarcase? You guys read it more carefully, that giving you the discretion to either go in-house or go to the courts. I don't know that this is analytically the best way to think about it as a non-delegation doctrine, but maybe through the back door they're getting at an attack on these in-house attorneys, that you have unfettered discretion to say, show up for your performance review in an hour and decide the case in the next half hour. I mean, the abuse is just so obvious.
All right. I think that's about it for us. Thanks very much. On behalf of the New Civil Liberties Alliance and our esteemed panel, I want to thank everyone for attending. We look forward to you attending future luncheon laws. We don't have one set yet for the next one, but please stay tuned, and we'll let you know when the next one's scheduled. Thanks very much.
Thanks, Dennis.